Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin and Kerrigan. I've been practicing in New Hampshire for about 38 years and in the Commonwealth of Massachusetts for about 28 to 29 years. I'm licensed and practiced in both states. So I'm going to concentrate today about when you're a property owner and you have a claim being brought by somebody that says they did work on the property that you didn't contract with. You might have a general contractor that you're working with, and the sub isn't getting paid and they're making a claim, or I've had a lot of these where I'm a commercial landlord. I represent a landlord that has a tenant that has work being done on the property and they don't pay, and then the contractor makes a mechanics lien or other claims against you. I'm going to talk about what those types of claims are. Generally in New Hampshire, a subcontractor, when they're making such a claim, they have some limited choices. Usually they're going to be suing the person they contracted with, plus they're going to be suing the owner if they can. And when they're suing for both of you, one of the things that they might argue in a general claim, and I've seen this quite a bit, is a breach of contract. Well, if they're claiming the defendant's a claim for breach of contract in their lawsuit, first thing you're going to say with your attorney is you're going to ask for a dismissal of that because there's no contract between you and that subcontractor or that person that did the work for the tenant, perhaps for you. So in those situations, you want to first address this with the attorney about getting a motion to dismiss. You may have, in a commercial lease situation, you might have an obligation by the tenant, and I put this in regularly, for the tenant to actually remove any types of liens or claims against the property. And if they do that quickly and they get you dismissed from any type of lawsuit, great, but otherwise you should get counsel. And you shouldn't be in a situation relying on the tenant to do the right thing because they obviously had some rift with the contractor to begin with, and you don't want to rely on that. So if there's a claim for breach of contract, your attorney should be moving to dismiss that, saying that's a motion upon which you state there's failure to state a claim upon which relief can be granted. There is no contract, so you can't make this claim. Good argument. Another claim that will come out is called the mechanics lien statute. RSA 447 in New Hampshire is a mechanics lien statute. There's a subsection 5, 447:5, that deals with the issue of owners. And if you're in a situation as an owner and there's a lien being placed upon your property for a mechanics lien, and you're able to show that you didn't contract with this person that's making this claim, and if you're in a situation where you are contracting with a general contractor and the subcontractor is the one who's making the claim, first you want to look to see if in your contract you already had the subcontractor make a mechanics lien waiver. That's a possibility. So each time there was a payment, they may have been required to make a mechanics lien waiver. That's very helpful because then there's a release of that claim. But even if they haven't, to the extent you paid everything that you're supposed to the general contractor, and the subcontractor didn't give you written notice ahead of time saying, look, I'm out here and I'm going to make a lien claim, so you better watch out for that. Absent them doing that before they do the work, you have a good defense on the mechanics lien statute saying it's not my responsibility, it's between the general contractor and the subcontractor. Now, in the practical effect with that statute, that notice requirement, I haven't seen in the 38 years I've been practicing many subcontractors thinking it's good business sense to give a notice to the owner, hey, I'm out here, I don't trust my general contractor, be careful, you better make sure you don't pay them without paying me. In that situation, certainly the owner would be requiring joint checks to make sure everyone's paid, but also the general contractor and the subcontractor are never going to have a business relationship ever again. So that type of argument would be, notice requirement would be the subcontractor would be shooting themselves in a business foot. The other claims that can be out there is called quantum merit or unjust enrichment. They're two really different claims, but New Hampshire hasn't really done a good job so far in clarifying the two. Quantum merit is more of an implied in fact contract saying, based upon the circumstances, I should still be able to make a contract claim. Perhaps there wasn't consideration for the agreement. There's some other reasons for it, but it's basically saying, you know I'm out here, and you know that you have a responsibility to me, and there's an implied in fact contract, something out there that you knew that you were expecting to have to pay this. That's a tougher argument. Often what I'll also see is what's called unjust enrichment. Unjust enrichment is a claim saying hey, I put this value into this property. You knew I was out there, and you can't go and turn around and say, even though just because you don't have a contract with you, that I don't get paid at least the value that I've added. It's not the contract value. If the contractor is saying, look, this was $30,000 worth of work, but the real value to you is $15,000, the claim is validly, if the court finds that, is $15,000. But that's also to the extent that you haven't paid off your general contractor. If you're in a situation where you paid your general contractor everything he's owed, and the general didn't pay the subcontractor, the unjust enrichment claim should fail. Likewise, with the tenant situation, if the unjust enrichment claim is out there and the tenant had this work done, the question about unjust is also, well, contractor, why didn't you contact the landlord? Why did you think that the tenant had the right to make these improvements onto this property? Did you look at the lease ahead of time? Those types of arguments you want to deal with for the unjustness of it, and then you also want to deal with the value. I've dealt with these issues quite a bit at Hamlin and Kerrigan here in Nashua, New Hampshire. I'm at 603-883-5501, 603-883-5501. Also, you can check out my weekly vlogs that are all by different title. You can look by title and decide choices of interest to you. You go to Nashua Law, our firm website. It's Nashua Law, all one word, .com, and click onto my bio, and from there you can get onto my YouTube vlogs. Look forward to working with you if the opportunity arises. Dan R. at 603-883-5501 at Hamlet and Kerrigan here in Nashua, New Hampshire. Thank you.